The third lecture of the online series. Please note that classes were canceled by Jackson Yale University for both Friday, the 20th of March, and Monday, the 23rd of March, but that the material that is expected to be covered before the end of the term has not changed. Accordingly, this lecture contains attendance requirements and a quiz, which is due on March 25th before midnight by email response to me. Mailbag. A student has asked whether or not a court will enforce an excessive liquidated damages clause by reducing the amount to one that is reasonable. The answer is that such clauses are considered to be penalty provisions, and that damages are then limited to the actual provable damages for the breach of contract. This class begins what may be the most important aspect of the class for most business majors, certainly those that are going to be working in the United States in connection with retail or other environments, which is the Uniform Commercial Code, sales and lease contract provisions. The Uniform Commercial Code, better known by its initials, UCC, is a set of statutory enactments which have been adopted in large part in every state and in connection with sales and leases in every state with the exception of Louisiana. In this chapter, we'll discuss Article 2, which concerns sales of goods, and Article 2A, which is a recent cloning off of Article 2, which applies to leases of goods. The formation of sales and lease contracts, how that differs from ordinary common law contracts, title and the risk of loss, which are particularly important in the case of these commercial transactions. Contracts for the international sale of goods is also considered at the end of the chapter. Surprise. This is the first quiz question. Make sure that you answer all of the questions in an email to me at the address shown on the screen no later than midnight on March 25th, 2020. The questions are located throughout this lecture. The first one of these questions is, damages that repay the non-breaching party for the injuries or losses actually sustained as a result of the breach of contract are called A, compensatory damages, B, consequential damages, C, punitive damages, or D, nominal damages. Make sure that your email includes both the number of the question and the letter of the correct response. By the end of this chapter, you should be able to answer each one of the following 4 questions without either consulting any notes or going back through the materials. First question. If a contract involves both goods and services, when does the UCC apply? Second question. What happens if an acceptance to a sales contract includes terms which are additional to or different from those in the offer? Third question. When does risk of loss pass in a shipment contract? And finally, what law governs contracts for the international sale of goods?
Landmark in the law.
the Uniform Commercial Code. In the early years of this nation, sales law varied from state to state, and this lack of uniformity complicated the formation of multi-state sales contracts. To remedy this situation, the National Conference of Commissioners on Uniform State Laws began drafting the UCC in 1945 and actually completed their work pretty much by 1949, a legal landmark. Over the next several years, the UCC was substantially accepted by almost every state in the nation. UCC articles are periodically revised to adapt its provisions to changing business customs and practices. Second quiz question. Answer all of the questions in an email to me no later than midnight, March 25th, 2020. Questions are located throughout this lecture. This is the second of those questions. Number 2, foreseeable damages that result from a party's breach of contract but are caused by special circumstances beyond the contract itself are called A, compensatory damages, B, consequential damages, C, punitive damages, or D, nominal damages. Make your selection and make sure that you have the number 2 by the letter that is your choice in the email that you're going to send to me by midnight on March 25th. The scope of Articles 2 and 2A of the Uniform Commercial Code. Article 2 of the UCC governs sales contracts, which are contracts for the sale of goods. A sale is defined as the passing of title, that is evidence of ownership rights, from the seller to the buyer for a price, which can be money, goods, or services. To be characterized as a good, the item of property must be tangible, and it must be movable from place to place. Tangible property has physical existence. It can be touched or seen. On the other hand, intangible products or intangible properties such as corporate stocks and bonds, patents and copyrights, and ordinary contract rights are only conceptual in their existence, and thus they do not come under Article 2. What about services? Services likewise are not tangible property and ordinarily do not come under Article 2. But when a contract involves a combination of goods and services, courts generally use the predominant factor test to determine whether a contract is primarily for the sale of goods or for the sale of services. So, for example, if a plumber is repairing a broken pipe in your house, that is almost invariably going to be considered to be a service. Goods that are associated with real estate are generally referred to as fixtures. And because they are so closely associated with real estate, are considered not to be movable unless they are detached from the real estate. When they are a fixture, ordinarily they're not going to be considered to be a good unless they've been physically detached, at which point they can regain their status as a good. different states will have different concepts of what a fixture is, and they can be fairly nuanced at times. So, in some states, a drop-in range, which is one which is not actually physically attached to the counters, but which nonetheless sort of looks like it's attached to the counters, is not going to be considered a fixture, whereas it might be considered one in other places. A slide-in range, on the other hand, which is genuinely independent as a unit, is almost always going to be considered just a good rather than a fixture, while something like a cooktop or a built-in oven is almost always going to be considered to be a fixture. Ceiling fans in some places are considered fixtures, but in others they are not. Again, this is one of those things where even though we have a uniform law concerning the sales of goods, we don't necessarily have uniform laws in every state regarding what is going to be a good, or whether it can shift back and forth between the idea of it being associated with real property as a fixture or being a good. While the UCC Article 2 and Article 2A regarding sales and leases of goods do apply to all transactions involving goods, standards can be different depending upon the status of the people that are involved in the transaction. So accordingly, merchant is held to different standards from the casual seller or buyer. Who is a merchant? A merchant is a person who regularly deals in goods of the kind involved in the sales or lease contract. Merchant holds himself or herself out as having unique knowledge and skill regarding such goods, or a merchant is a person who employs another merchant as a broker, agent, or other intermediary. So you can be a regular, what would otherwise be casual buyer or seller, but because you have gone and employed someone who deals regularly in that kind of goods as your agent or broker, that makes you into a merchant for the purposes of that transaction as well. Um, Quiz question number 3. Once again, answer all the questions in an email to jwinkle1@ju.edu no later than midnight on Wednesday, March 25th, 2020, if you want to receive credit for this quiz. Given the present circumstances regarding the spring term, I would strongly urge you to participate in this quiz. The remaining questions are located throughout this lecture. Question number 3. Damages that try to deter similar conduct in the future are called A. Compensatory damages. B. Consequential damages. C. Punitive damages. Or D. Nominal damages. Once again, please make sure that the number of the question is associated with the letter of your answer in the email that you will be returning to me. On page 396 of the textbook, but also here in this slide, we have Exhibit 16-1, the law governing contracts. This exhibit graphically illustrates the relationship between general contract law and statutory law, in this case, UCC Articles 2 and 2A, governing contracts for the sale and lease of goods. Sales contracts are not governed exclusively by Article 2 of the UCC, but are also governed by general contract law, wherever it is relevant and has not been modified by the UCC. Thus, in the upper left-hand corner box, we have the words General Contract Law, an arrow which marks controls, points to non-sales contracts, contracts which are outside the UCC, such as contracts for services and for real estate. Connected to the general contracts box is the relevant common law being case-made law by judges and courts, which has not been modified by the UCC. What controls? It controls under what circumstances? It controls contracts for the sale and lease of goods together with statutory law, which are UCC Articles 2 and 2A, which simultaneously control contracts for the sale and lease of goods. Quiz question number 4. I will not repeat the instructions which have appeared previously on the other 3 questions. Question number 4. A small monetary award granted when no actual damages are present is called A. Compensatory damages, B. Consequential damages, C. Punitive damages, or D. Nominal damages. Once again, please associate the number of the question with the letter of, hopefully, the correct response in the email that you will be sending me. UCC Article 2A, which is a relatively recent addition to the statutory provisions of the Uniform Commercial Code, governs leases of goods. What's a lease? A lease is a transfer of the right to possess and use goods for a period of time in exchange for payment, rather than being an out-and-out exchange of the title to the goods in exchange for a payment. Article 2A of the UCC was created to fill the need for uniform guidance and guidelines in this area. Article 2A defines a lease agreement as the bargain between a lessor and a lessee with respect to the lease of goods, as found in their language and is implied by other circumstances, including the course of dealing and usage of trade or course of performance. A lessor is one who transfers the right to the possession and use of goods under a lease. A lessee is one who acquires the right to the temporary possession and use of goods under a lease. In other words, the lessee is the party who is leasing the goods from the lessor. A commercial lease isn't covered under this subject. But a consumer lease is, and a consumer lease involves 3 elements. 1, a lessor who regularly engages in the business of leasing or selling goods. 2, a lessee who leases the goods primarily for personal, family, or household use. And finally, total lease payments that are less than a dollar amount, which has been set by state statute. I want you all to recall for a second the idea behind an agreement under the 4 required elements of a valid contract. What was required for an agreement? You had to have an offer and you had to have acceptance. What we're going to talk about right now in terms of the Uniform Commercial Code is offer. So a sales or lease contract is sufficiently definite even if one or more of the terms remains open. And this is totally contrary to the mirror image rule. Provided that, first of all, the parties intended to be bound, and secondly, that there is a reasonably certain basis for a remedy in the event of a breach. So, first, open price terms. As a general rule, if the parties have not agreed on a price, the court is going to determine a reasonable price at the time of delivery. Now remember again, this is only applying to the sales or leases of goods. However, if one of the parties is permitted to set the price, he or she must do so in good faith, or if the parties have not agreed on the price due to the fault of one of the parties, the party who is not at fault can treat the contract as canceled and fix a reasonable price. Open payment terms. If the parties do not specify otherwise, payment is due at the time and the place that the buyer receives the goods. Moreover, the buyer can tender payment using any commercially acceptable means. However, if the seller demands payment in cash, the buyer must be given a reasonable time to obtain it. Open delivery terms. If the parties do not specify the time or the place of delivery, in the case of the place of delivery, the buyer will take delivery at the seller's place of business. Or if the seller doesn't have a place of business, then at the seller's residence. The time of delivery must be within a reasonable period of time after the contract's been made. Open duration terms. If a contract does not specify how long the parties are going to deal with one another, either party may terminate with reasonable notification. And as to shipping arrangements, if a contract requires that the seller ship the goods to the buyer, but does not specify how, the seller may, in good faith, make commercially reasonable shipping arrangements. Okay, guys, I understand that this is fairly dense stuff. And if you have not been looking at the freely available Cengage online version of Miller's book, you really need to go and read Chapter 16 on UCC sales and leases, because in many ways this utterly is the heart of this course. And of course, you can't really get this down unless you've got a basic understanding of the law of contracts generally. So you're going to have to go back over that if you don't have a firm grip on the basics of contract law. So going forward, and I would suggest strongly that you go over this slide, the one before it, probably more than once, more than twice, in order to try to get this down. So, going on with open terms. Open quantity term. If you failing to specify the quantity the parties agree to buy and sell is fatal in common law. Obviously, it does not meet the mirror image rule. However, the UCC recognizes two exceptions to that. In an ordinary sale of goods, like common law, they're not going to allow you to have a failure to specify the quantity of the goods that you're buying. That's not true under these two circumstances. That of a requirements contract, whereby the buyer has agreed to purchase and the seller has agreed to sell all or up to a stated amount of what the buyer needs or requires. And in the case of an output contract, where the seller agrees to sell all or up to a stated amount of what the seller produces. Obviously, these are not contracts that are entered into by casual sellers and buyers. Obviously, these are entered into by either wholesale and retail merchants, or by manufacturers and wholesalers, or between very large commercial entities. Um, Option and output and requirements contracts are something that you'll frequently see with utilities regarding the purchase of either the underlying carbon products that are necessary in order to generate electricity, or possibly for electricity itself. It's something that you'll frequently see with very large retailers, such as Walmart. Tends to be abused by retailers such as Walmart, because they are able to manipulate the fact that they have a requirements contract to their advantage when it comes to certain suppliers of certain products. That said, the Uniform Commercial Code does impose a good faith requirement on requirements and output contracts, such that the actual quantity purchased or sold cannot be unreasonably disproportionate to normal or comparable requirements or output. But it is a frequent source of litigation when dealing with the unscrupulous party on the other side of your contract. Another exception to the common law is what's known as a merchant's firm offer. And again, this is something that certain brands of common law regarding the law merchant would probably have recognized the concept of the merchant's firm offer even prior to the UCC. What happens here is that while at common law, an offeror has the power to revoke her offer at any time prior to its acceptance by the offeree, unless the offeree pays consideration for an option, for the offeror's irrevocable promise to keep the offer open for a stated period of time, an option contract. In this case, the UCC has created a second exception for firm offers to sell or lease goods made by a merchant. And again, let's go back to the definition of merchant. Remember that the UCC is a code, and the way codes work statutorily is that they will have statutory definitions of certain terms. One of those terms, which we just went over a few minutes ago, was the definition of a merchant. And as you will recall, a merchant is somebody who regularly trades or deals in goods involving the particular kind of good that is involved in this transaction. So if a merchant has made an offer that is irrevocable, they don't have to have consideration regarding that offer for a stated period of time, as long as they either state the period of time for it or it's for a reasonable time, but neither of those two periods is to exceed 3 months. So firm offer, even if it's made by a merchant who says nothing about the length of time, so a merchant can come forward, a rug merchant comes forward and says, I'll sell 5x7 rugs for $100. That offer is good, that offer is valid, without there being any consideration paid for an option to purchase those rugs, but not for any longer than 3 months. Now, in times like these, where we have the coronavirus outbreak, there's certain kinds of merchant's firm offers that, if they haven't already been revoked, it might be impractical to actually come in and perform. And that's another question that we'll be getting to a little later. Quiz questions number 5 and number 6. These are true, false questions. Accordingly, when you answer the question, place the number of the question and the word either true or false after the number of the question in the email, which will be returned to me as the answers to your quiz. Question number 5. Liquidated damages provisions in contracts not to compete are always enforceable. Question number 6. A penalty clause in a construction contract is enforceable as long as the amount is reasonable. Make sure that these 2 questions are answered in the email that you are going to return to me. Once again, everybody, I want to return to the basics of contract law. The 4 elements that you have to have in order to have a valid contract, as you'll all recall, start out with agreement. An agreement has to have both an offer, we've just been over that, and an acceptance. Acceptance in common law is different from acceptance under the Uniform Commercial Code. And we're going to go over that now. Acceptance of an offer to buy, sell, or lease goods generally can be made in any reasonable manner and by any reasonable means. The UCC permits acceptance of an offer to buy goods, quote, either by a prompt promise to ship or by the prompt or current shipment of conforming or non-conforming goods, close quote. Note the use of the word promise. And also note that conforming goods are goods that accord with the contract's terms, whereas non-conforming goods do not. So the prompt shipment of non-conforming goods constitutes both an acceptance, which creates a contract, and a breach of that contract. This rule does not apply if the seller seasonably, which means within a specified time period or a reasonable period of time, notifies the buyer that the non-conforming shipment is offered only as an accommodation, which is as a favor. It's important that you understand the meaning of the word seasonably. Under the UCC, the offeror must be notified within a reasonable time that the offeree has accepted the contract by beginning performance. Otherwise, the offeror can treat the offer as having lapsed before acceptance. To reiterate, the prompt shipment of non-conforming goods constitutes both an acceptance, which creates a contract, and a breach of that contract. But that rule does not apply if the seller seasonably notifies the buyer that the non-conforming shipment is offered only as an accommodation. Communication of acceptance is required, meaning that the offeror must be notified within a reasonable time that the offeree has accepted the contract by beginning performance. Otherwise, the offeror can treat the offer as having lapsed before its acceptance. The UCC dispenses with the common law mirror image rule. In other words, an acceptance must match the terms of the offer exactly. I've discussed this on some prior slides. It takes instead the position that a contract is formed if the offeree's response indicates a definite acceptance of the offer, even if the acceptance includes additional or different terms. If any party is a non-merchant, the contract is formed according to the terms of the original offer, and the additional terms in the acceptance are ineffective unless the offeror separately agrees to them. In other words, the only time the mirror image rule is truly dispensed with is in the case of both parties being merchants. So if both parties are merchants, the additional terms automatically become part of the contract, unless the offer expressly limits acceptance to the terms of the offer, the acceptance's new or changed terms materially alter the contract, or the offeror objects to the acceptance's new or changed terms within a reasonable period of time. And once again, the question of what is a reasonable period of time is going to vary depending upon what kind of transaction it actually is. The offeree's expression cannot be construed as an acceptance if it contains additional or different terms that are explicitly conditioned on the offeror's assent to those terms. Finally, in a dispute over contract terms where the parties' writings contain different terms, the UCC allows a court simply to strike from the contract those terms on which the parties do not agree. Quiz questions number 7, 8, 9, and 10. These questions are going to require a very, very short answer response. List the 4 types of equitable remedies for breach of contract. After each number, I want you to list one of the 4 types of equitable remedies, and one only. Accordingly, your answer to number 7 will consist of one of the 4 types of equitable remedies for breach of contract. Your answer to number 8 will consist of another of the 4 types of equitable remedies for breach of contract. Your answer to number 9 will consist of a 3rd type of equitable remedy for breach of contract. And your answer for number 10 will be the 4th and remaining type of equitable remedy for breach of contract. Make sure that each one of these questions and its associated answer is included in the email that you're going to be returning to me no later than midnight on March 25th, 2020. I want you all to recall once again that in addition to having to have an agreement, one of the 4 fundamental things that you have to have in order to have a valid contract is consideration. Unlike under common law, the Uniform Commercial Code contains no additional consideration as a requirement to support a contractual modification, although it does require consideration in order to form an agreement in the first place. In some situations, a modification to the contract, even though not necessarily requiring additional consideration, must be written to be enforceable. And any modification has to be sought in good faith. A writing is going to be required if the contract provides that any subsequent changes have to be in writing. Or if a non-merchant seeks to modify a merchant's form contract that contains a no oral modification clause, or if the proposed modification would bring the contract under the Statute of Frauds. And again, go back, recall the circumstances under which the Statute of Frauds is applicable, and in the case of a sale of goods, It's if the amount involved is $500 or more. UCC Article 2, which applies to sales, requires a writing under the UCC Statute of Frauds if the sale of goods is for $500 or more. UCC Article 2A, regarding leases, requires that the contract be evidenced by writing in order to be enforceable if the lease of goods involves scheduled lease payments totaling $1,000 or more. The writing must indicate the party's intent to agree, and the writing must be signed by the party against whom enforcement is sought, not necessarily by both parties. The UCC provides a special rule for merchants in sales transactions. Merchants can satisfy the statute of frauds if, after the parties have agreed orally, one of the merchants sends a signed, written confirmation to the other merchant within a reasonable time. That communication has to indicate the terms of the agreement, and the merchant who is receiving the confirmation must have reason to know of its contents. There are, however, a number of exceptions to the UCC Statute of Frauds requirement that the contract be evidenced by a writing. Merchants' written confirmations, if a contract for the sale of goods is between two merchants and a written confirmation is signed and sent by one merchant and sufficient to enforce the contract against the sending merchant, it's also sufficient to enforce the contract against the receiving merchant, unless he or she objects in writing within 10 days of receiving the confirmation. For specially manufactured goods, an oral contract is enforceable if it is for goods that are specially manufactured or obtained for the buyer or lessee. Those goods are not suitable for sale or lease to others in the seller's or lessor's ordinary course of business, and the seller or lessor has substantially started to manufacture or otherwise obtain the goods. Additional exceptions to the statute of frauds include admissions. An oral contract is enforceable if the party against whom enforcement is sought admits its existence in pleadings, testimony, or other court proceedings, but only to the extent of the quantity of goods so admitted. This is no different from the standard rule in common law contract cases. Finally, in the case of partial performance, an oral contract is enforceable if the buyer has made and the seller has accepted payment for the goods, or if the buyer lessee has received and accepted the goods, but only to the extent of the quantity paid for or accepted, respectively. Once again, you are provided with a schedule. This exhibit appears in the book of the major differences between contract law and sales law. This exhibit has 3 columns: topic, contract law, and sales law. Topic, contract terms. Under contract law, the contract must contain all material terms. Under sales law, open terms are acceptable if the parties intended to form a contract, but the quantity term normally must be specified, and the contract is not enforceable beyond the quantity term. For the topic of acceptance, the mirror image rule applies in contract law cases. If additional terms are added in acceptance, a counteroffer is created. Under sales law, additional terms will not negate acceptance unless acceptance is made expressly conditional on assent to the additional terms. Under the topic of contract modification, Under standard contract law, modification requires consideration. Not so with sales law, where modification does not require consideration. The topic of irrevocable offers. Under contract law, option contracts with consideration are irrevocable. Under sales law, merchants' firm offers without consideration are irrevocable. Statute of Frauds requirements also differ between standard contract law and sales law. In the case of the common law of contracts, all material terms must be included in the writing to satisfy the statute of frauds when a writing is required. Under sales law, the writing is only required for the sale of goods priced at $500 or more, but the contract is not enforceable beyond the quantity specified. Merchants can satisfy the requirement by a confirmatory memorandum evidencing their agreement. Exceptions exist for specially manufactured goods, admissions, and partial performance. Once again, recall that under the common law, there is a parole evidence rule requiring a court to not go beyond the terms of the contract if they're all expressed in the contract itself. In the case of the UCC, there is also a parole evidence rule. If the parties to the contract have set forth its terms in a writing intended to be the final expression of their agreement, the terms of the writing cannot be contradicted by evidence of any prior agreement or contemporaneous oral agreement. However, the written terms may be explained or supplemented, in the case of the UCC, by evidence of course of dealing, which is the prior conduct between the parties to the contract that establishes a common basis for their understanding, usage of the trade, any term, practice, or method of dealing that is so regularly observed in a place, vocation, or trade that it is reasonably expected to be observed by the transaction in question. And finally, course of performance, which is the conduct of the parties that occurs under the terms of a particular agreement, which indicates what the parties to that agreement intended that agreement to mean. The rules of construction that are used in the case of the UCC may differ slightly from those used under common law. The express terms of the writing, the parties' course of performance and course of dealing, relevant usages of trade, and any consistent additional terms are to be construed together when they do not contradict one another. However, should a conflict arise, the UCC provides the following order of priority among conflicting terms. Highest is express terms that are contained within the writing that is the contract. Next, course of performance of that particular contract that we're talking about. Third, course of dealing between these particular parties. And then finally, the courts will resort to usage of trade. Unconscionability. As I've said before, in the case of common law, don't rely on doctrines like that of unconscionability in order to get you out of having made a stupid deal. However, the doctrine exists, and so an unconscionable contract is one that is so unfair and one-sided that enforcing it would be unreasonable. The UCC permits a court to evaluate any contract or contractual provision, and if the court determines it was unconscionable at the time it was made, the court may refuse to enforce the contract in its entirety. It may sever the unconscionable clause and enforce the remainder of the contract, or the court may limit the application of the unconscionable term to avoid an unconscionable result. Again, don't rely on a doctrine like this, because courts, to the extent that they attempt to be conservative and not make law, are going to be very reluctant to apply a doctrine like that of unconscionability. The classic case of Jones versus Star Credit Corporation, New York, 1969, is found in the current edition of Miller, starting at page 409. Facts. The Joneses, the plaintiffs, agreed to purchase a freezer for $900 as the result of a salesperson's visit to their home. Tax and financing charges raised the total price to $1,234.80. After making payments totaling $619.88, the plaintiffs brought a suit in the New York State Court to have the purchase contract declared unconscionable under the UCC. At trial, the freezer was found to have a maximum retail value of approximately $300. Issue. Could this contract be denied enforcement on the ground of unconscionability? Decision. Yes. The court held that the contract was not enforceable and reformed the contract so that the Joneses were not required to make further payments on the freezer. Reason. The court relied on UCC 2-3021, which states that if the court, as a matter of law, finds the contract or any clause of the contract to have been unconscionable at the time it was made, the court may so limit the application of any unconscionable clause as to avoid any unconscionable result. The court then considered the disparity between the $900 purchase price and the $300 retail value, as well as the fact that the credit charges alone exceeded the retail value. These excessive charges were exacted despite the seller's knowledge of the plaintiff's limited resources. The court reformed the contract so that the plaintiff's payments, amounting to more than $600, were regarded as payment in full. Again, don't count on a doctrine like this, even in the state of New York, as a method of getting out of a stupid deal. Title and risk of loss. In order to establish the circumstances under which title can change hands, and likewise, in order to provide for an insurable interest so that a party does not have a risk of loss, we have to look at identification of goods. Before any interest in specific goods can pass from a seller to a buyer or from a lessor to a lessee, two conditions have to be met. The goods have to be in existence, and they must be identified as the specific goods that are designated in the contract. Identification is significant because it permits the buyer or the lessee to insure the goods and to recover from third parties who damage the goods, in transit or otherwise. If the contract calls for the sale or lease of goods that already exist in their final form, then identification occurs at the time the contract is made. If the contract calls for the sale or lease of goods that have not yet been completed or modified in accordance with the contract, Identification occurs when the goods are shipped, marked, or otherwise designated by the seller or lessor for delivery to the buyer or lessee. Future goods have special rules applying to the identification. For instance, there's special rules regarding growing crops and unborn animals. Fungible goods are goods that are alike by physical nature, by agreement, or by trade usage, such as grains of wheat, barrels of light-grade oil. Identification of these goods occurs when the goods are shipped, marked, or otherwise designated by the seller or the lessor for delivery to the buyer or lessee. Students whose ID number ends with the digit 1, enter the word Bush in comments to prove attendance. Passing title. The UCC provides that unless a contrary agreement is explicitly made, title passes to the buyer at the time the goods are physically delivered to the buyer. In the case of a shipment contract, a contract for the sale of goods in which the seller is required or authorized to ship the goods by a carrier, the seller assumes liability for any losses or damage to the goods until they are delivered to the carrier. For destination contracts, which is a contract for the sale of goods in which the seller is required or authorized to ship the goods by carrier and tender delivery of the goods at a particular destination, the seller has assumed liability for any losses or damages to the goods up until the point at which they are tendered at the destination specified in the contract. In other words, in the shipment contract, the seller is no longer liable once the goods have left the seller, but they are still liable under a destination contract up to the point at which they are delivered to the buyer. In the case of delivery without movement of the goods, it depends upon a document of title, which is a paper exchanged in the regular course of business that evidence the right to possession of the goods, for example, a bill of lading or a warehouse receipt. When the sales contract does not call for the seller to ship or deliver the goods, as in when the buyer is to pick up the goods, the passage of title depends upon whether the seller must deliver such a document of title, such as a bill of lading or a warehouse receipt, to the buyer. Let me point out that as I go through these slides, when you see a reference to a case on the slide, just because I haven't read you the details of the case out loud doesn't mean that it's not important. Doesn't mean that it won't be illustrative of these ideas that are contained within the chapter. And it doesn't mean that you shouldn't go and read the case, and for that matter, the entire chapter. Risk of loss, delivery, or tender. Under the UCC, risk of loss does not necessarily pass with title. When risk of loss passes from a seller or lessor to a buyer or lessee, is generally determined by the contract between the parties. When the contract involves movement of the goods through a common carrier but does not specify when risk of loss passes, the courts look first for specific delivery terms in the contract. So obviously, a shipment contract contains the specific requirement that title is passing at the time that the seller has delivered the goods to the carrier. But The risk of loss is not actually passing to the buyer until the seller has delivered the goods to the carrier, which is totally consistent. Likewise, in the case of a destination contract, where title is not passing to the buyer until the point at which the buyer is receiving the goods at a particular destination, risk of loss, likewise, is not passing to the buyer until the carrier makes the goods available to the buyer at the designated destination. Students whose ID number ends with the digit 4 enter the word Roosevelt in comments to prove attendance. In the case of bailments, bailment is a situation in which the personal property of one person, a bailor, is entrusted to another, a bailee, who is obligated to return the bailed property to the bailor or dispose of it as directed. Goods that are held by the seller. If the seller is a merchant, risk of loss passes to the buyer at the point that she takes physical possession of the goods. If the seller is a non-merchant, risk of loss passes to the buyer when the seller tenders the goods to the buyer. In the case of goods held by a bailee, risk of loss passes to the buyer when the buyer receives the title document from the seller, the bailee acknowledges the buyer's right of possession, or the buyer receives a non-negotiable title document and has had a reasonable period of time to demand the goods from the bailee. Students whose ID number ends with the digit 3 enter the word Cleveland in comments to prove attendance. Risk of loss when the contract is breached. When the seller or lessor provides the buyer or lessee with goods that are sufficiently non-conforming as to entitle the buyer or the lessee to reject them, risk of loss is not passed to the buyer until either the seller or lessor cures the breach by somehow correcting his or her performance within the contract period, or the buyer accepts the goods despite their defects. When a buyer or lessee breaches a contract for sale or lease of goods, the risk of loss immediately shifts to the buyer or lessee, but only if the seller or lessor has already identified the goods. The buyer or lessee only bears the risk of loss for a commercially reasonable time after the seller or lessor has learned of the breach, and the buyer or lessee is liable only to the extent that the seller's or lessor's insurance does not cover the loss. Students whose ID number ends with the digit 0 enter the word Lincoln in the comments section to prove attendance. Insurable interest. A property interest in sold or leased goods that is sufficiently substantial to permit a party to insure against damage to the goods identified to the sale or lease contract is known as an insurable interest. A buyer or lessee has an insurable interest once the goods are identified to the contract. A seller or lessor has an insurable interest as long as he or she retains title to the goods. Even after title has passed, if the seller retains a security interest in the goods for payment still due, the seller can insure the goods to the extent of that interest. Students whose ID numbers end with the digit 8 enter the word Washington in comments to prove attendance. Contracts for the international sale of goods. The 1980 United Nations Convention on Contracts for the International Sale of Goods, or the CISG, governs international sales contracts between firms or persons located in different countries, as long as the countries in which the parties to the contract are located have ratified the CISG. Each party to the contract knows or has reason to know that the other party's place of business is in another country. The parties to the contract have not otherwise agreed that some other law will govern their contract, and the contract is not for the sale of consumer goods. In other words, goods intended primarily for personal, family, or household use. A comparison of the CISG and the UCC. Statute of Frauds. The CISG contains no requirement that a contract for the sale of goods be in writing. Offers. The CISG permits an offeror to simply state orally that the offer is irrevocable. Moreover, the CISG deems an offer to be irrevocable if the offeree reasonably relies on it being so. Acceptances. The CISG provides, subject to certain exceptions, that any purported acceptance containing terms that materially alter those in the offer is a counteroffer rather than an acceptance. Otherwise, additional or different terms in the acceptance do not keep it from being treated as an acceptance. You have reached the last slide of a very long but very important chapter that ordinarily, in a classroom setting where we had a full number of classes available to us, would undoubtedly have taken at least 2 classes. However, this is probably the heart of this course, and you really need to have some knowledge of the Uniform Commercial Code if you're going to be in any kind of business practice in your future life in the United States of America. Stay well, and I hope to be able to see many of you in the future.